I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, everyone. I would ask to begin tonight's meeting and see if there's any public comment from the board this evening.
Mr. Chairman?
Mr. Ebersol.
I got a few things. I just wanted to say, I don't normally try to correct the press, but contrary to what was published in the Ledger, I was not the one that said that the town election was not done by the book. That was the town council who made that comment. Secondly, I wanted to let people know that the general bylaws as posted by the town clerk on the website are not accurate. The PAC bylaw was outdated. The sewer commission still shows appointed members, and the Board of Health still shows one member appointed by the Board of Selectmen, all of which were changed. Those last two were changed by the charter. I personally think that these bylaws should be taken down, as it's dangerous to have information that's inaccurate. It'd be better to have no information than information that's not correct. And then lastly, in preparing for tonight's hearing, I asked the town accountant for any payments made to the establishment. 4 payments were made by the clerk's office for food for elections. I believe this is a violation by the town clerk of the ethics law due to the familial relationship between the parties. What my biggest concern is that there may be a breakdown in systems that would allow this to happen, just as it did with a prior superintendent of schools. I would like to, as we did with other town departments, department heads, I'd like to have a meeting sooner than later with the town accountant just to go over what systems may need to be instituted. I believe that we need to be open to concerns and complaints and remain transparent so everyone can hear what's going on. Thank you.
Anybody else from the board? Before I ask for the public comment from the public, just a few announcements. First is our annual fall yard waste days are coming up. They will be on beginning Saturday, October 12th through Saturday, November 23rd, inclusive, all Saturdays in between there from 8 a.m. to 4 p.m. at the Lunenburg landfill off of Youngs Road. Acceptable material will be, as always, grass clippings, bark mulch, wood chips, leaves, brush with a diameter not to exceed 3 inches, shrubbery and plantings with the same restrictions. Any container, bags, boxes, barrels, trash cans, tarps, flower pots, etc. must be removed and taken by the resident. No household garbage, trash, or rubbish of any kind will be accepted, and no materials within the landfill area, be they sand, stone, gravel, etc., are to be given away or sold. Access will be restricted to the disposal area. Commercial landscapers will not be allowed to dump, and it is open to Lunenburg residents only. Travel permitted only on the town easement, and no trespassing on Tri-Town Landing development property. Second is to my continued announcement that next Monday, September 23rd at 7 p.m., the Department of Public Utilities has scheduled the public hearing to receive comment on Unitil's petition for rate increases. It is open to the public. You will be able to speak if you would like, and I encourage people to go and attend and or speak at it. It is at the Fitchburg Memorial Middle School at 615 Rollstone Street in Fitchburg, Mass. Again, next Monday, September 23rd at 7 p.m. And lastly, the Boys and Girls Club of Lunenburg is having their annual charity auction, and that is at Thursday, October 10th at 6 p.m. at the Bull Run. Always a good event for a good cause, so I would encourage people to attend.
Mr. Chairman.
Mrs. Bertram.
I would just like to go back to the public comment because, I just want to, I don't know the circumstances regarding the 4 payments for food for the elections, but before we talk about similarities between the superintendent of schools and our existing town clerk, I think that's a stretch right now. I think that we don't know the circumstances. We don't know whether there was an ethics law violation. If food was paid for and provided and consumed, that's a very different scenario than past experiences with our former superintendent of schools. So I would like to find out whether or not an ethics violation did occur before we make statements such as that. I think that that's inflammatory, and I think that we need to know all the facts, and this is first coming to us. So I would ask that, as someone who's made inquiries to the Ethics Commission, it's a free service. We can talk with an attorney at the Ethics Commission and find out whether or not there is a potential violation there.
Thank you. I would comment that I would agree that equating somebody who embezzled $450,000 for his own purpose and somebody purchasing $600 of food for election workers seems to be not on the same scale. And I would urge and caution members of this board that those kind of comparisons don't serve anybody well. And I think that if there are complaints and things to investigate that we would like seen, I certainly welcome the transparency, but we should keep things in scope and proportion.
Mr. Chairman,
Mr. Ebersol.
Duly noted. I was not talking about, and I did not mean to intend that the scale was the same. I want to make sure that we have an accounting system that will catch these things as they happen and not depending upon comments by people shared with me or that I investigate myself.
Okay.
I agree with the intensity of that comment is not the appropriate connection. It's the systems that need to be fixed.
Thank you. Any public comment from the public? Okay, so first thing is appointments to the Council on Aging. We have 3 people, or I hope we have 3 people in attendance, who are replacing members who are not looking to be reappointed. And they are, and I guess you can all come up together. We don't have to do them individually. We have Judith Tarbell, Tony Bertone, and Shirley Bertone.
Once again, I'm Mary Lynn Conrad. I'm the chairman of the Council on Aging. And I have come tonight because, as Tom said, we have lost 4 members this year. We have lost 3 very dedicated members who were with us for their whole term, and then Jim Hayes had resigned. So we were looking for 4 new members, and we've recruited 3. And since you've already introduced them, I will reintroduce them as Tony and Shirley Bertone and Judy Tarbell. And unanimously, the COA has voted for them to be appointed. So we'd like to present them to you tonight.
Excellent. And if each of you just individually can just introduce yourself and just say a little brief thing about yourself, just so we like to let the people know who you are when they see you, and introduce yourselves to the board. Nothing lengthy, just something short. It doesn't matter which way you want to start.
I'm Judith Tarbell.
You just come to the mic, yeah, just so the people at home can hear.
I'm
Thanks.
Judith Tarbell. I was on the Council of Aging, and I had to go off because it can only be on for so long. So I'm going back on again.
Oh,
and I really enjoyed it, so that's why I'm returning.
Well, thank you.
We're very happy to have you.
I'm Shirley Bertone, and I've been here in Lunenburg for 10 years, my husband, and we enjoy this town very much. You have a beautiful, quaint town here. I hope to be here many years and to be serving the Council on Aging as long as I can.
Thank you.
I'm Tony Bertone. I spent 5 years, 5 years with the Eagle House doing odd jobs, Meals on Wheels, kitchen help, and just looking to go further, do more.
Excellent. Well, first, as we always do, thank you to all 3 of you for volunteering for a very important committee and a great cause. And the Eagle House and the Council on Aging do a great job over there for the seniors of this town, and they continue to do so, and I'm sure under your stewardship they will continue to do so. Any questions or comments from the board? I would entertain a motion on the 3 nominees in front of us.
Mr. Chairman, I would move that we nominate or approve the nomination of Shirley Bertoni, Tony Bertoni, and Judith Tarbell to the Council on the Aging.
Second.
Any further discussion? All those in favor, please say aye.
Aye.
Opposed? None. Congratulations to all of you.
Thank you.
And thank you to all of you.
Okay, we have another appointment. We'll go down the public weighers at Keating's. And could you brief us on this?
I
please?
can. These are annual appointments as public weighers. You did make or ratify some appointments. These are appointments that are actually made under Section 4-2D, which is a town manager appointment board ratification. You did make these back at a meeting in June. However, two of the individuals that were appointed are no longer employed by P.J. Keating, so we're replacing them with two other individuals, Robert Croto and Bruce Walker. And these public weighers are responsible for ensuring the accuracy of quantities of materials that are purchased from P.J. Keating's. And they're, in this role, they're really serving a role on behalf of the town as a weigher, just to certify that the devices that are used to measure and weigh quantities are accurate. So very similar to what our sealer of weights and measures does, but because of the quantity of transactions at P.J. Keating's, they have individuals right on site.
So we have two individuals, Robert Croto and Bruce Walker. And I would entertain a motion from the board on those two appointments as public weighers working at Keating's.
So moved?
Second?
I'm assuming the motion is to approve.
Yes.
Any further discussion? All those in favor, please say aye.
Aye.
Opposed? None. So Mr. Croto and Mr. Walker are appointed public weighers. Okay.
I can do.
Or we can start, I guess. What would you rather?
No, I can be quick.
Okay.
Okay. I have a couple of updates while we're trying to get to 7:15. We had a good presentation at your last meeting from Jack Rodriquins and our engineer from World Tech on the pavement management program. And I wanted to follow up and just make an announcement of the work that we will be doing this fall. So this fall, with our Chapter 90 allocation, we will be doing some work on Northfield Road from Route 13, just beyond Settlers Crossing Golf Course. We're going to do a level and overlay and berm in critical areas and do some work on driveway aprons. We will also be working on Route 13, on Northfield Road from Route 13 at Gilchrist Street, doing a level and overlay. Again, some berm work and driveway aprons. And then, assuming that we have some time left and our funding allocation holds out, we'll be potentially doing work on White Street from Mass Ave to the Fitchburg line, level, overlay, and aprons. With the note that the decision will be made to do a section of White Street, depending on funding and, if the update to the plan shows something different, but we're holding that as our third project right now. We will also be doing some crack sealing, which is where we will put down either a hot or cold mix to level out the road, fill the cracks, which is why we call it crack sealing on Pratt Street, Memorial Drive, Robbs Hill Road, Graham Street, Hillside Drive, and Sunset Lane. This is about $34,000 worth of work that we will be doing. Another quick announcement, it's not too early to get a flu shot. I guess that's the commercial. Right now, we don't have clinics scheduled in Lunenburg, but we do have clinics that are available to Lunenburg residents through the Neshoba Associated Boards of Health. There will be some information on the website, but in the month of October, most Tuesday, Wednesdays, and Thursdays, there are flu shot clinics that are available in surrounding communities. And again, if you are interested, please visit the town's website, lunenburgma.gov, for some additional information on clinics, and we will be scheduling some within the town as well. I have one more, but it's longer, so I will hold off.
Okay, at 7:15, we have a hearing pursuant to Mass General Law, Chapter 138, Section 23, to discuss alcoholic beverage license number 0636000039 for 324 Electric Avenue. Manager of record, the license holder is B&H Corporation, doing business as Mickey Shays. Just to recap, a letter that was sent, certified mail to the corporation, addressed directly to Mr. Robert Herrick, is that on September 17th, 2013, at 7:15 p.m., the Lunenburg Board of Selectmen will hold a hearing pursuant to General Law, Chapter 138, Section 23, to discuss your alcoholic beverage license at 324 Electric Avenue, Lunenburg. The hearing will be held in the Joseph F. Pilata Meeting Room, 2nd floor, Lunenburg Town Hall, 17 Main Street, Lunenburg, Mass. The hearing will concern the status of your licensed establishment and specifically your manager of record. The board has information that your manager of record, Kyle Blood, is no longer employed at your establishment or affiliated with the business, and that this has been the case since as early as 2010. You may attend this hearing and be represented by counsel at your own expense if you wish, and these allegations, if proven, may constitute violations of Mass General Law, Chapter 138, Section 26, and/or 2004 CMR Section 2.01, subsection 8, in that you do not have a manager that has been approved by the Board of Selectmen, and that the Alcoholic Beverage Control Commission, and you may have filed one or more renewal applications under oath with false statements as to the identity of the manager. These allegations, if proven, would constitute grounds for disciplinary action, including a written warning, suspension, or revocation of your license. And that is the hearing that is before us. I would ask if the representative of B&H would come forward. You have received this letter, obviously.
I did, yeah.
And I will let you begin if you would like to start.
My statement, okay. Back in 2010, when I purchased the business from my partner, we were represented by counsel, both buyer and seller represented by counsel. In March of that year, my partner came in front of this board looking for another license for a new establishment. At that time, we found out that he was still listed as manager at Mickey Shays. The confusion there was we thought that the attorney had filed for that change of manager, and he did not. At that time, I told the board that I would do that. I went to the secretary, your secretary. I was told that I had to generate a check for $200 payable to the ABCC, which I did, and I dug out my check register to show that that check was generated on March 9th. I submitted the check to the secretary and received it back about 10 days later. And what she told me was I had to file through the ABCC. I wrote a letter to the ABCC requesting a change from my former partner, Kyle Blood, to my new manager of record, which was Lindsay Achilla, who was always the designee from 2006 when we bought the place. That letter was forwarded to the ABCC. I never heard anything back. 3 months later, my partner received a liquor license from the ABCC and from the board. At that point, I assumed that everything was taken care of. I never wrote his name down again as a manager of record, but I did endorse renewal applications that had his name on it. It wasn't, it wasn't anything that I did. I assumed that the paperwork hadn't caught up yet, and it was just something that was lost track of. But we've never been without a manager or a manager's designee.
Just for the record, so in your recollection, when was Mr. Blood terminated as manager?
Officially, everything was filed appropriately through the Secretary of State, and those records indicate that it was in January that he was taken as manager and off manager, and Lindsay was...
January of?
2010.
2010.
That was the purchase date, January 26th.
Okay. Okay, so, but we have November 19th, 2012 renewal. We have November 30th, 2011, and November 30th, 2010, all having Mr. Blood listed as manager, all with your signature.
That's correct.
So if he was bought out or terminated as being associated with your corporation
Exactly,
at that point, why would, it's not a lengthy renewal, it's one page. Why would you sign it with him as manager?
In those situations, we send the check in for the license renewal. Again, I never wrote down anything. I simply came in and endorsed a form, and that form had his name on it. I can't change that name. It can only be done by you or this board or the ABCC. Inasmuch as he had already received a license, I assumed that it was a lack of paperwork or lag in paperwork.
Mr. Chair,
Mr. Ebersol.
based on what Mr. Herrick just stated, is this form generated by our office similar to other licenses that come before us that we sign?
Well, I think I might be able to clear up a little confusion here. In the almost 30 years that I've been a license holder, I've never done a change of manager. So what I sent to the ABCC was not the 10-page form that you see or that you generate now off the computer. It was a letter indicating the change or the request for the change.
But when that, okay, so the form was given to you, and certainly you're saying that you have no authority to change that.
No form was given to me.
You have a signature that you signed.
Right, that form, yes.
Okay, so you've signed that, but you
Yes,
know...
I did. I endorsed that form, yes.
Right. And if you endorse the form, one would be led to believe, certainly I would be led to believe, that you are indicating that everything is proper on this form. That if something was not on there that was right, that you wouldn't have signed it and you said, well, this has to be corrected.
Well, exactly, but I can't correct that.
Not 100, you can't correct it on this form, maybe.
Right.
But there are mechanisms that you would have to correct it.
Right. As I say, I never received anything back from the ABC telling me that something was inappropriate or wrong.
Well, they wouldn't know that Mr. Blood is or isn't. They're not going to check whether he's employed by you, so they're not going to...
And at the point, several months after we had that issue in 2010, in May of 2010, several months after that, he was issued a license. So I had to presume that the paperwork had been done.
Anybody have any questions right now? Just want to look something up.
Mr. Chairman, the question I have is who was the manager during this time period?
During this 3 years,
Yes.
Lindsay?
I have been.
She has been. She has been the manager, actually appointed manager's designee in 2006. So myself as a corporate officer and she as the manager's designee, we were always, one of us was there the required amount of time.
All right, so the manager that we just officially appointed a month ago was the manager during the 3 years of the.
I'm sorry, Bob, I have.
Sorry, the manager that we appointed, Lindsay, was the manager during the 3 years.
Yes,
Okay.
absolutely.
I want to ask, we have town council here. I want to ask our town council, Attorney David Dineski, I want to ask him a question. If he would come to the microphone, please. Just want to be clear that change of manager is incumbent upon the licensee to provide, and that is state law, correct? Anytime there's a change of manager, according to chapter 138, it's their requirement to notify the licensing authority.
Each license holder under the statute must have a manager that is approved by the local licensing authority, which here is this board. It's also in your regulations that no manager shall be changed unless and until approved by the board and by the ABCC. So yes, it would be incumbent upon the license holder to request the approval, which is what's required under the statute of the licensing authority for a change.
So, thank you. So my point would be that twofold. First of all, it's important as you sign this that you are noting, because it says clearly above your signature, I hereby certify and swear under penalties of perjury that the renewal symbol is the same time, and all the, everything here would be accurate. That's number one. So the ABC is not required to find out that that's not, nor is this licensing authority. It's upon you to make sure that that's changed.
Right, but
Okay?
but Tom, I'm not allowed to change that. It has to come through.
No, because there are mechanisms, as you already did 2 weeks ago, that you
Right.
did change it. So
Right.
you do have the power to change it. You may not have the power to change the form, but by looking at the form, you should not have signed it and said, no, we got to get this changed first. Okay? That is state law, which under the license that is needed to be posted in your establishment says that you have to, the licensee is granted and accepted upon express condition that the license shall, in all respects, conform to all provisions of the Liquor Control Act, Chapter 138 of the general laws. By not telling us that you changed manager, we did not approve that. And by doing that, not once, but 3 years in a row, constituting what I think is in effect, a false renewal application, let that persist for 3 years. Okay, so I have a serious problem with that. If it had been addressed and it was 1 year, I may be able to say, even then I would have trouble. I'll be very honest with you. I'd have trouble because it happened 10 months prior that you and Mr. Blood had parted ways. But the fact that it had gone on for 3 years, I don't see, that's a pretty serious oversight from a licensing authority in my view.
Again, and the only thing I can respond to that is that Mr. Blood, having received yet a new license, I didn't have the change of manager. I didn't get that information back, but someone gave him a new license, and which would have made him on 2 licenses, which it can't be. That's.
Well, I don't think that that something that may have happened with Mr. Blood negates the fact, that what's going on here was, to me, a clear violation. So what happened with him may be one as well. I'm not saying, no, that him being on 2 is an issue, but we're not talking about him right now. We're talking about your establishment. The fact that the ABC gave him a license is a separate issue than not filing change of manager and then filing false renewals. I think they're very, very
I'm operating under the assumption that would be changed when they changed it through the ABC and through the board, that I'm not empowered.
The board is who you'd go for a change of manager, not directly to the ABCC. You would come to this licensing authority by our own rules and by the state law as well.
I have a question. When the manager did change, did you submit any paperwork to anybody to
To the ABCC,
to
yes, I did.
inform them with
Not
this one?
the form that I sent in just a week and a half ago. It wasn't that form. It was a request form for change of manager. It was a letter that I generated, along with the fee for change of manager fee.
With the name of a new manager?
Right, the name of
Which
the
is
new
the-
manager and to take off.
And do you have a copy of that?
I don't have that copy, no.
Did you have a copy of that canceled check?
Pardon me?
Did you have a copy of that canceled check that you sent to the
I don't
ABCC
have
3
the
years
check.
ago?
I have only the check register was written in. And I received nothing back from them.
Anybody else?
I think, yes, you can't change a name independently. We surely can't change the name of a manager of your establishment either independently. So that's bothering me. 3 years in, 3 years of bad information to us, no effort to resolve it. That's a real challenge.
I mean, the effort was made in the very beginning in the March of 2010. I mean, I did what I was supposed to, what I was told to do, what I was supposed to do. I can't go in every time when I do that license renewal. I mean, again, it was one of those things that just, each year, when the change caught up, the change would come.
3 years?
But I had done.
But every time you put your signature on that, you acknowledged, presumably, that you read that and everything was accurate. And if it was me, I would say, I'm not going to sign it because it's not accurate, and I would find a way how to change that to make it accurate. That was important. And
Sure.
the license given clearly states that it's up to the licensee, the person receiving the license, to conform to it. There are express details in the chapter and our own bylaws that state, and you're required to know them, that when you change managers, you have to come to this licensing authority. There's no evidence, and I don't think you're even suggesting that you came to this authority, this licensing authority in town. You went to the ABCC.
No, I came here first.
He said he came here
I
first.
came here first,
When?
in 2010.
Do we have any record of any change of manager?
That's when I submitted the check made out to the ABC to the Selectman Secretary. I got it back and was told that I had to file through the ABCC. It's just when I generated the letter, forwarded the check.
Did you ever meet before the board, or you just went to the office?
I went to the office. I mean, we had the meeting here when my former partner had applied for a new license, and he couldn't get one because he was listed as the manager still. And that was something that wasn't handled by our attorney, which I said that night that I would handle. I did. I went to the secretary here. It came back to me a week and a half later. I was told to forward everything I had to apply through the ABCC, which I did. 2 months later, my former partner got a license. I assumed that all that paperwork had been taken care of, and the fact that his name was on the renewal was just a matter of a paperwork.
Mr. Chairman,
Mr. Ebersol?
when you received the check back from the town, did you receive a letter with the check?
No.
Or-
No, I generated the letter.
No, when the town sent you back the check, you said you gave a check to the secretary here at Town Hall,
Right.
and you received the check back.
She called me, I came and picked it up.
It wasn't a letter, it was a phone
I came and picked it
call.
up. I didn't get a letter from her.
Can I just question that process? What would I believe there's a form here that needs to be filled out as well. Is that, so I'm confused as to how that could have occurred.
you asked a question whether or not there was anything in the file indicating that anything happened in 2010, and I did just look through the file, and I'm not seeing anything in that file. When there is a change of manager, that happens here locally. I'm not sure why anybody would direct Mr. Herrick to the state. I'm not saying they didn't, but I don't know why that would have occurred, and the ABCC would just send it back here anyway, because the local licensing authority has to approve the change of manager or any changes to a liquor license before the ABCC will even take it up as a matter. So I can see if something did go to the ABCC that they would send it, it would come back to you because it needed to originate here locally. But again, I'm not seeing anything in the file, so it's hard to say what happened and when.
But we have had numerous, since I've been on this board, numerous change of managers for liquor licenses. So there is and nobody is new in the selectman's office. Anybody who would have been there in 2010 has been there for a long time and would know that. So I don't know do you remember who you spoke with?
I'm sorry.
You remember who you spoke with? Here, when you asked for that in 2010.
When I asked for the change, the board, the Board of Selectmen, that's who I was in front of.
When you asked for a change?
No, when they directed me to do the change.
Who
The
called you?
change of manager hadn't been done when my former partner applied for a license. When he was in front of the board, I was here also.
Yeah.
Because I was requested that I be here to find out why it hadn't been done. 6 weeks after I bought him out, he was still listed as the manager. That's when we thought our attorney had done it, but he didn't, and that night I told the board that I would take care of that. As what I was told to do was to generate a $200 check and bring it here to the selectman's office, which I did. Then it was given back to me. I picked it up, nobody sent it. I picked it up and I was told I had to file this I had to request this through the ABCC.
Who told you that? That you had to request it through the ABCC?
Secretary.
I mean, I do remember the discussion when Kyle Blood was here. And I do remember talking about this and Kyle Blood saying that he was, asking to be removed as the manager, and I'm sure Mr. Herrick said he would file the application. That whole process, I know we had that discussion here. It doesn't appear that it happened. And there may have been some confusion. I mean, the same person is handling liquor license issues in the office as has for a number of years. This is a little different where you have a manager, on one license coming off and opening his own establishment. So, I mean, in any event, even if there was a mistake and he was directed to the ABCC, the directive would have come back from the ABCC that you have to handle it here. And, we didn't follow up with the licensee either.
Who is we didn't follow?
We in the office. I mean, Linda and I have talked about this. Should we have been more proactive in this? And, we weren't, because we rely on the information that's in the license renewal applications. We don't have a
Oh, you're talking about
process.
catching it.
Right.
Okay, but we're not, but that's separate. I mean, the point is that 2 weeks ago or 3 weeks ago, 2 meetings ago, when there was a change of manager made officially, there was paperwork that has existed in its exact form that was filled out. It was the same exact form, my understanding, in 2010. All those forms for change of manager, all that process would have been exactly the same.
Yes.
And there is not, we don't have any evidence of it. And all Mr. Herrick is saying is that he doesn't have any written evidence of it. It's just that he had a conversation during another meeting for another application or another applicant. Mm-hmm. Well, that doesn't qualify as a change of manager form to me.
Right. No, I would agree with you. Yes.
I'm assuming you see the position
I do.
that we're in, and the gravity of
I do.
those 3 renewal applications.
And I take responsibility for that.
Okay. So, what would this board like to do? Obviously, we have authority in our bylaws, and they are, anything from a warning, suspension in extreme case, and I don't know that this necessarily, and I'm speaking as one person, falls under that. It's certainly, we have the power of revocation, but that's not something that I'm...
Mr. Chairman, just a point of order. First offense is warning to 7-day suspension.
Right.
That would be the limit. We actually cannot do a revocation.
Well, I would, okay, that's fine. But I don't think, I think
Mis-
you could
Mr.
argue that there's...
Mr.
more-
Chairman, I could argue that there's 3 offenses.
Right. And the fact that we're catching them now, I mean, that's, the order of them and the severity of them obviously is, you're right. And the number of offenses, the fact that we're catching them, it says that we can't go back and look at other offenses before then, but we're catching them all at the same time.
My take on this is, as a license authority, we depend on the business owners, the establishment owners, the license holders, to manage their businesses appropriately, to manage within the law, to communicate with the town effectively, whether it be us or be the police or whatever it might be. I think there's been a serious breach of that. It makes you wonder what else isn't done, isn't in line, isn't being properly followed through on. This is pretty significant. If it was a year later and, the partner left and it wasn't caught, okay, that's one thing. But 3 years in, it's either willful, just don't care, or just not paying attention.
It's not a matter of caring. This is my livelihood and the livelihood of about 14 other people. I care.
Yeah.
Again, I take responsibility for this. And, in signing those renewals, I'm looking at it and I see, I didn't always see that, but I know now his name was on there each and every time. I probably should have looked and maybe perused that document a lot closer. But again, I'm not the one that can change that name. And in as much as he had already received another license, and I understand your point on that, Tom, but to my way of thinking, in order for him to get a license, he would not have been able to been on another one.
Again,
So if
as
paperwork takes
a
time-
licensed authority, this is a working relationship between you, the business owner, and us.
Understood, and I don't think...
And again, it's clearly outlined, the responsibilities
Sure.
of owning that license, having that license from us. Clearly outlined. And, there's big verbiage in there about, perjury, making sure this is accurate. Like you said, you've been in this business for 30 years. I've been in my business for 30 years.
And
I know if I get a document and it says, under penalties of perjury, make sure this is accurate, God damn it, I'm making sure it's accurate. 3 years in, I'm making sure it's accurate. So, all due respect to the concerns about whether or not he had another license, I get it. Maybe there was a miss. Bottom line is, it's on you to be sure when you sign that.
It's on me.
And if there's we made the change of manager pretty effectively a couple weeks ago. I think we're pretty easy to work with as a board, as a licensed authority. But there's got to be, equal effort on this.
Now, I understand the quid pro quo of all of that, but again, as a 30-year license holder, I don't have a string of offenses. I have nothing, really. I have this instance. And as was mentioned, it's very confusing. I've never done a change of manager in 30 years.
Yeah.
I did what I was told and what I thought was appropriate. Never any intent to misrepresent who was there and what was being done. I don't have a string of offenses. I've never been without a manager. But I do take responsibility for endorsing those 3 years without the proper manager on it.
For the record, I also want to note that it was not your establishment who recognized and brought to this board.
I understand.
Okay, that's important too. It's not like you came to us and said, you know what, this is the third year it's been on here, we need to get this off. It was brought to us by a third party.
I understand.
Okay. So my guess is, and I'm only projecting this because of past, that come this November, if that hadn't been brought to our attention, we would be seeing yet another application. Now, I realize that's conjecture into the, projection into the future, but historically, from what we have in front of us, I think it's pretty fair to say that we probably would have been looking at another application with the wrong manager on.
I've admitted already that in order for it to go that long, I had to have lost track of it. But again, assuming that it was being taken care of at appropriate levels, it wasn't something that I could change.
Again,
I know.
I don't think that's accurate, but okay, I understand your point.
Mr. Chairman, this is a serious violation. It is your responsibility to understand both the general law and our local bylaws. And I know that they're long, I know that they're involved, and you may not have done it in 30 years, but it was your responsibility to go back and look at the document and to understand what your responsibilities were. I do understand some of the confusion surrounding it. However, the reality is it is your responsibility. But I also agree with you that there isn't a string of violations for this establishment, that this is what I would consider a first offense, although I can understand how you could argue it's the third offense. Personally, I think revocation would be too strong, and I would like to focus now. We've talked about the circumstances surrounding it. I think all of us agree that a serious error was made, but now I think we need to talk about, as a board, how we want to move forward. And personally, I would prefer to keep it to a warning or to a suspension of some limited time. I personally would be against a 7-day suspension. So that's where I'm at.
Mr. Chairman?
Mr. Ebersol.
I will echo Mrs. Bertram's comments, and my concern is not only with this license holder, but with other license holders, and what message we send to make sure that we're not having to, and not that I would expect that we would be checking and driving into each establishment to see if the managers are actually there. I think there needs to be at least a warning and perhaps a suspension for a short period to make sure that all license holders know and that we're consistent going forward. The other question I would ask is, I don't know when the last time this board dealt with a violation of a liquor license for any purpose.
We did a couple of years ago for an issue with reporting a crime and working with the police department. And we suspended their license for
3 days.
3 days.
Okay.
There was a question about the last time there was an issue. It's probably been, I would say, 2 years.
I already answered that.
What's that?
I answered.
Oh, I'm sorry.
Mrs. Bertram helped me.
What
you were about to. A couple of years ago, waterfront, 3 days.
And it was relative to a crime on a premises, and we've voted to revoke the license for 3 days.
So my take on this, again, we try to work and be supportive of the establishments in town. Like you said, you get 14 people that work there. 14 people want to make a living. We want to make sure they make a safe living, and it continues on. My take on it is, I think it's a serious offense. I think suspension's in order. I think basically a day for each year, 3 days, makes sense to me, personally.
Mr. Chairman, may I?
Uh-oh.
This is just a procedural recommendation that before you actually take a vote on any sanction that you choose to impose, that you find by vote the violations for which you would impose that sanction. And from what's on the record, my recommendation would be a vote with respect to a false statement submitted on the renewal applications for license years 2011, 12, and 13, which is
10, 11, and 12.
10 The application would have been submitted in 2009, and at that point, Mr. Blood was still affiliated with the business.
The renewals dated 2010, 11, and 12.
Yes.
Okay.
Yep. For those years going
Yep.
forward.
And also, I think it would also be for not notifying this board of a change of manager. So not only providing false information on an application or renewal, but also for not following the bylaw and the chapter for providing us with a timely change of manager.
Yes.
So that would be 4.
You could find that as well. I'm just making the recommendation so that you have the predicate for any sanction.
Gotcha.
I
appreciate that.
I would like to go back to the renewal for 2010 for a second, because my understanding is that when the renewal application was submitted in 2010, Kyle Blood was the manager and changed subsequent to the renewal
No, it's not
application.
correct.
That is not correct?
No.
That's a question.
Okay,
And
I'm
when you
sorry.
submitted the renewal application in 2010, was Mr. Blood the manager at that time, or was
Yes.
he was the
He
manager
was
at
the
that time?
manager in 2010.
My understanding from what you said earlier was that you terminated or you parted ways with Mr. Blood on January 26th of 2010.
Right.
But yet in November of 2010, 10 months later,
For 2011.
right, but I'm just saying the application, I'm being very clear
Right.
that it's for the renewal applications that are dated
Right.
on November of 2010, November of 2011, November of
Okay.
2012.
For the subsequent years?
Right, so they
Okay,
are for
I
the
got
following
you.
years, but those are the applications that we are concerned about. And that application in November of 2010 came 10 months after Mr. Blood was no longer part of B&H Corporation. Okay, so at the advice of town council, procedurally, we should indicate how we find and the findings and the violations. Now, again, as I said out loud, when that was brought to our attention, in my mind, we have 4 violations. Violation number 1 would be the failure to notify the licensing authority of a change of manager of record at the establishment. And then there'd be 1 violation every year for supplying false information on the renewal of the application. All the applications, as I said, dated November 2010, November 2011, and November 2012. That's what I believe the B&H Corporation is in violation of.
I would that was a motion?
Well, just offering that. You could
Okay.
make that a motion.
I would make that a motion as far as findings.
I would second that.
Any further discussion on those findings? All those in favor of those findings, please say aye.
Aye.
Aye. Opposed? None. Now we get from that determination.
As to the issue of what steps this board should take, I would agree with Mr. Matthews that it's a serious offense. I would agree that a written warning should be done. I would also agree with a very limited suspension. I personally think that 3 days, as was stated, there are 14 individuals who rely on this establishment for a living, and I think that 3 days is too severe. I would personally prefer to do 1 day.
Anybody else? Recommendations?
Mr. Chairman, I echo my colleagues' statements that it's a very serious situation. I do believe that a suspension is in order and would be willing to split the difference on 2 days.
Horse trade.
I think it is imperative to the process that people signing applications for renewals, whether it is by neglect or disregard of any nature, that those are serious. And it really, to me, jeopardizes the whole process, as well as the failure to follow our own bylaws and their own chapters that are required, stated clearly on the license themselves. It is that nature of severity. I do not agree with my colleagues that a warning or a 1-day suspension does anything to prove any point in identifying and trying to prevent these kind of lapses for other license holders in the future. I would go much more on this. I think at least 2 days per incident, and I would offer a suspension from at least 6 days, 6 business days for this. But this is very serious, and I think a 1-day suspension does not, and this is my own opinion, obviously, does not really coincide with my colleagues saying that it's very serious and a 1-day suspension. That doesn't really mean anything to anybody. I understand the employees would be held, there would be some payment that they would be making because of this violation that they had nothing to do with, but it is important that we keep proper the whole intent of the bylaws and the chapters of Mass General Law to begin with. So,
Mr. Chairman, I just would like to comment. I think that this is an establishment that has been in business for a long time. There is not a string of violations associated with this. While I agree that it is serious, we have all seen notices from the ABCC in which actions have been taken against various establishments in town in which suspensions were ordered and then lifted subsequent. And it's very rare that an establishment has actually been closed. And in all the years that we've been a licensing authority, I'm only aware of one establishment which we actually closed. And frankly, I think that some of the other violations that the ABCC have found are more severe than this. I am not negating the fact that this is a serious violation. But I also think that when you take into account that this is a business that has been in town for a long time, it does not have a string of violations. It's a well-run establishment. We do not have a series of reports of issues at the establishment. I think that a 1-day liquor license suspension is a financial burden. I think that when you get into something of two days times every violation, now you're making the finances you're hurting the finances of not only the business, but the individuals who work there, and in such a manner that I question whether or not they would be able to recover, because I would question whether individuals would remain employed. So I think that we've got to weigh what our objective is. Our objective is to send a message that when you sign a license renewal, you are certifying that statement is true. And I think that moving forward, I think that this does send a clear message to individuals who have a license. But I think it's imperative that we balance both the businesses in our town and our laws. And I think that a 1-day suspension, and I would even be willing to split the difference, as Mr. Toll suggested, and go to 2 days, but I would be opposed to anything more than that.
Have you ever been found in violation by the ABCC
No.
in Mickey Shea's existence?
No. Not serving underage, not anything like that.
Any
Nothing.
violation?
None.
No.
Mr. Moderator, the license regulations that this commission adopted, the objective of the regulations is the prevention of violations, and violations will be prevented because regulations will at last require license holders to operate in accordance with a clearly defined higher standard. My concern with going with a higher number is that if the last time this licensing commission adopted was a 3-day revocation for failure to report a crime, which I consider to be a very serious criminal, and seeing this as more of a civil, I think that our penalty at this point should be less than that 3, and I would recommend a 2-day suspension.
Seems like the ship has sailed. I can live with 2. Personally, I think it's inadequate. Personally, I don't necessarily think we have to assume that if it closes, employees don't get paid. That's entirely up to Mr. Herrick. It's entirely up to how he operates his business. And if he's responsible for the shortfall here, how he manages that's up to him. But I can live with 2.
In regards to balancing the employees against the owners, I certainly am sympathetic to those, but if we use that standard, then by that right, what I would ask, what would constitute a higher penalty? What would an owner have to do? What would a licensee have to do to get that? Where 14 employees, would not outweigh that. I mean, I am very, very sensitive to the fact that it's going to cost people wages that it had nothing to do with them. However, again, keeping the integrity of the whole system and the bylaws in place, and to me, perjury is fairly serious. Providing false information is fairly serious. Obviously, I'm outvoted here, so I will allow that. But I have to say on the record that this warrants way more, in my mind, way more serious a suspension for that, because of the number of violations and the length of time that they were allowed to go on, and that it wasn't even the applicant or the licensee who even caught it to correct it, to end it all. So, anyway, I would entertain a motion to, I think there was a penalty offered, but in the form of a motion for B&H Corporation.
Before you make the motion, in the motion, you should also identify when the suspension will be served.
And I would like to make one other point, by the way, that suspension of the license does not mean that the establishment has to close. It means that they can't serve liquor. So that is clear in the bylaw. So when people say that we have to close it, that is not accurate. We are not closing them for the suspension. We are just suspending their ability to serve alcoholic beverages during that period.
What are your normal hours that you're open?
11 a.m. till 1 a.m.
Is that all 7 days?
2 o'clock on Thursday, Friday, and Saturday.
Okay, and Sunday you're all day?
1 o'clock.
Okay. So I would recommend, if we're going to do a 2-day suspension, it be for the most painful days of the week, quite simply, and do it Friday, Saturday.
Do we have to provide dates?
You should provide dates, and they should be, I would say, at least 2 weeks out to give us time to have council prepare the letter to make sure it's in the right format.
So that would put us at October, what's about the 18th and 19th?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
All those opposed? Only because I think it should be more, I am going to oppose. So that would be served. We will get the proper paperwork.
We will, within the next week, you will receive a letter in the mail instructing you that you actually have to bring your license to Town Hall, and we do hold that during the term of the suspension, and then it is available to pick up immediately after the suspension is served. And if that occurs after hours, then the license is available to be picked up at the police station, but that will all be specified in the letter.
I would also suggest highly that there are other procedures that are documented in our bylaw that you have to do during that suspension, and that you follow them.
I have the bylaws.
Okay. Thank you.
Thank you.
Good night.
Thank you for your time, too. You're welcome. All right. Okay, review and approval of earth renewal permits.
This is a request to renew existing permits. We do this annually at this time of year, and I do read through each permit, identify the number, the applicant, the location, just for the record. The first renewal is for Permit 1, Ralph Montori Construction Company at 186 Massachusetts Ave. Second is Permit 8, William R. Proctor Incorporated, off Mass Ave, Northerly. The second is the third, Permit 14, P.J. Keating Company, west side of Fort Pond Road, adjacent to Lancaster. Permit 15, P.J. Keating and Company, northerly Leominster Shirley Road and westerly of Reservoir Road, both sides of B&M Railroad. Permit 16, P.J. Keating Company, northerly Leominster Shirley Road and easterly of Reservoir Road, both sides of Round Road. Permit 17, P.J. Keating Company, southerly Leominster Shirley Road and easterly of Fort Pond Road. Permit 18, P.J. Keating Company, southerly Leominster Shirley Road and westerly Fort Pond Road. Permit number 19, P.J. Keating Company, easterly of Shirley Reservoir and northerly of B&M Railroad on the Shirley Town Line. Permit number 27, P.J. Keating Company, southeast corner of Lunenburg, approximately 1,300 feet inland from Leominster Shirley Road. Permit number 28, P.J. Keating Company, westerly side of Reservoir Road near Round Road. Permit number 29, P.J. Keating Company, westerly side of Reservoir Road, south and near Goodrich Street. Permit number 30, P.J. Keating Company, southeast corner of Lunenburg, approximately 2,200 feet inland from road abutting the Shirley Town Line. Permit number 42, P.J. Keating Company, Leominster Shirley Road. Permit number 32, Raymond A. Powell, Jr., rear of 395 Goodrich Street, approximately 1,150 feet inland from CNAS. Permit number 54, Powell Stone and Gravel, 151 Leominster Road. On an annual basis, we do have the building inspector, zoning enforcement officer go out and review the activity at each of these locations. He did put together a report of his findings with his final recommendation that he has found all of the gravel permits to be orderly and kept in a safe condition.
He has two listed that you do not. Number 5 and number 31, both A.C. Sozik, at the bottom of his list.
Oh, and those are inactive and have not applied for renewals.
They have not. So we're going to let those lapse?
Yes.
And all the others have applied for renewals?
Yes, they have, and I have the applications in the file.
I just have a question on number 32, which says pit is now 95% vegetated. Is that vegetation that has just, are you aware whether or not that's the actual grading that would be required if the pit went inactive, or whether or not that's just simply because the pit hasn't been exercised in that period of time?
Well, I couldn't say. I really couldn't say
I would probably, and I don't want to second guess the building official, but if you said it's a pit, probably that's not final grading, because if you look at number 8 under William R. Proctor, that's restored. He used the word restored there. This is just, I think, inactive, that just weeds are growing in it, personally.
Okay.
Although, because it's a pit, I don't think that the final restoration grading would be a pit.
Which leads to the next question.
Right, when it says restored 100%, are we saying that they can now re-excavate that on number 8?
He's asked for renewal, so right now, I guess the applicant is asking that it just be kept open, even though they're not doing anything with it. Maybe there's material there that he hasn't excavated and that is still there, but it's been graded over, so nothing is, I don't want to second guess again all these, but if the applicant has applied for renewal, we're just offering them a renewal, and this building official is just saying what state it's in.
Do you have a copy of the renewal applications?
I do. There's only 4 because if they have multiple, they've identified on the applications.
And they are all paid up on taxes, is that
They
correct?
do. That was the next note I was going to make. We do ask the treasurer collector to review all of these as well. And I do have a memo from her stating that taxes are current for all permit holders listed.
And we have no complaints about any of these locations?
We do not.
Excellent.
Mr. Chairman?
Mr. Ebersol?
I noticed from, I'm assuming it's the correct bylaw, the completion and closure of pits, the board may require a closure plan before an existing permit expires or is terminated. So my only concern of the applicants that did not seek to be renewed, has this board in the past talked about closure plans for any of these permits?
Not to my recollection. I'm just going to look in the file and see how long permit 35 and 31 have been inactive.
In regards to permit number 8, there has been activity in that pit within the last year, and about 100 yards of material was removed. So it's a very limited quantity in comparison to the other permits that list, for example, 50,000 tons. So it looks like, although that it does look, say, restored 100%, they are doing some minimal excavation and continue to do so at that area.
Mr. Chair, just following up on my earlier comment, I'm not going to recommend any holds on any of these permits because of the information provided, but I think this might be a good workshop, especially for me as a new member, to just revisit the earth removal bylaw, what we should be doing, what we can't do, because when you read the bylaw, the whole concept is to allow people to remove gravel, but at the end of the day, when the thing's done, the property is restored or it is closed in a way that's going to be suitable for the environment. Yeah. And I guess it'd be good if we came up with either standards or, because I remember many years ago, very controversial discussions about this, and that that's part of the reason why the bylaw was written the way it was. So I think we're just reacquainting ourselves with that process.
I would agree wholeheartedly, and that's why I question the restored, because there's actually a requirement for a restoration plan showing grading. So I do think it's something we should talk about and revisit moving forward. But as Mr. Ebersol said, I don't have any holds on these permits, and especially after looking at the renewal. But I do think we need to familiarize ourselves with that bylaw again and make sure that we understand the requirements as far as restoration.
I think the way the current bylaw is written is that it's not clear, because the first part of the completion and closure said the board may require a closure plan, and then it goes on to letter B that says the closure plan must be approved. So right. We're in the middle of what are we supposed to do. So I think there's some wording change that we need to do there, yes.
I did look in the file, and permit 5 and 31 were not renewed last year either.
Okay. So I entertain a motion on the earth removal permits and renewals as listed and by the town manager.
I would make that motion to approve all the permits identified by the town manager.
Second.
Any further discussion from the board? All those in favor, please say aye.
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 Aye. Opposed? None. Minutes. Oh, do we have to sign these? Okay, I'll give them at the end. Warrants. Accounts payable warrant in the amount of $675,441.45. Action file issues. Any?
No.
Okay, committee reports, Board of Health.
Board of Health met last night. Generally, most of their work are around lakes. Both Hickory Hills and Shirley Reservoir were on their agenda, dealing with installation of wells, how close the wells are to the lakes, how close they are to setbacks and various things like that. fairly non-controversial ones for those. Some have to go to Conservation Commission based on location, because most things in Hickory Hills are often within the buffer zone, and the same is true in Shirley Reservoir. Both dealing with any waivers for offset to groundwater. The Board of Health does have some discretion under the Title V, and they review that on a case-by-case basis.
Okay, Building Reuse Committee.
Yeah, we had a very good meeting last night. Each of the task teams brought in their initial thoughts, including preliminary plans and costs. We continue to work on fine-tuning the assumptions and validating variables, trying to take variables off the table so that we have a process that we can work with based on data. The next meeting is September 30th.
Excellent. Capital Planning Committee.
Meets tomorrow at 10 a.m. and we'll begin review of capital planning submissions on the 25th.
Finance Committee.
No meeting since our last update. Their next meeting is the 26th.
Library Board of Trustees.
Library meets on Thursday, but they sent out a notice that as the recession has pushed people to local libraries and has increased the use, and Lunenburg Library is similar to that for the usage.
Okay. MPO.
No report.
Planning Board.
No report.
PAC.
Tonight's meeting was canceled. I believe we're looking at a workshop of October 15th between the PAC and the board. There is an open meeting law complaint that needs to be resolved, as well as a meeting several years without a quorum. And I believe that will be topics for our agenda for the October meeting, since there's no PAC meeting tonight.
Okay. School Committee.
No report.
School Building Committee.
We are, next meeting at the end of the month, we have, a number of us have attended a number of the open houses at the schools, start to have conversations with parents. Hopefully that discussion will emanate out into the town and more people will start getting involved. We have to find ways to get people engaged, get more information to folks, so they have more familiarity with the process, what we've gone through to get here, the plan, the proposal, what it accomplishes, and the benefits thereof. So we have a lot of work to do between now and January when we have town meeting and a vote.
Okay. Sewer Commission.
Sewer Commission, the major item is that the intermunicipal agreement with Fitchburg for receiving sewage from the town the review has been completed both by Fitchburg's and Lunenburg's city solicitor and town council. They are going to send it to Tom and Paula, who are the point people for the Board of Selectmen to review for comments, to send that back to the Sewer Commission, hopefully for their Tuesday meeting next week, so that they can take action and then send it back to the entire Board of Selectmen. You may not have time to review that, but whatever time period it's going to take for you to review it, you get to make comments, send it back to the Sewer Commission, and if it's got to go through the cycle again, it'll go through that cycle, but the end will be, it will come back to this entire board. The Sewer Commission will make a presentation to the board for our review, comments, and final vote.
And we did receive it. At least I received it in the email today. So.
Okay.
I did receive it today. Unfortunately, I'm going to be leaving town on Friday, and I'm not sure that I'm going to get to it in time for Tuesday night's meeting, so I will be perfectly honest. I know the plan was for Mr. Alonso and myself to look at it and then bring it back to the board, but I think both of us, I think they've only been very minor revisions, and I don't foresee any problems, so I think it might make sense at this point to circulate it to the board so that we can put off any issues later. I know there's been some questions in other board members' minds on what's included, so I think it might make sense at this point to circulate it. We can certainly forward our comments, but I think it would give everyone an opportunity to review it in advance.
I would agree.
Me too.
And the mass broadband, there is no update. You had one more town manager report item.
I just wanted to give you an update on the casino project. I did have the opportunity to do a little bit of research last week and also to meet briefly with the applicant. So I just wanted to advise you, the state is issuing 3 full casino licenses, one in Eastern Mass, one in Western Mass, and one on the South Shore. They are issuing 1 slots license statewide. There are 3 applicants competing for that, one of which is the Leominster project. The other 2 projects are located basically in southeastern Massachusetts. So there is a general consensus among the people that I have talked to that there's a strong likelihood that the Leominster project has legs, so to speak, because of the location of all of the other applicants. The application for the slots parlor is due October 2nd or 4th, so that's coming up. The city of Leominster has negotiated a host community agreement, which is required. The next step is a referendum where voters get to decide, get to put in, to provide their opinion on this. It seems to be one of the criteria of the Gaming Commission how strongly the community supports the project. And they look at that based on what the margin is on the referendum. One of the projects that this is competing for on the South Shore had, I believe, an 84% voter approval of the project. The other project, the referendum is scheduled sometime around the same time as the Leominster project. The next process after that is the applicant has to meet with surrounding communities that are potentially impacted by this development. The town has been officially notified by the Gaming Commission that we are a potentially surrounding community. It gets a little confusing, but I mean, we're obviously a surrounding community, but whether or not we meet the definition of surrounding community where mitigation is required is something else. So the purpose of my meeting was to find out what type of information the developer had available in terms of traffic impacts and other types of impacts, because I think that's what we need to be looking at. The town of Lunenburg has no say in whether or not the project goes forward. Obviously, it's not here in Lunenburg. What we can comment on is the potential impact of the development to the town of Lunenburg. So of particular interest is the Route 13 corridor from the New Hampshire border through Lunenburg and down towards the project. The developer has suggested through their research that they are looking at about 100,000 people per year coming from New Hampshire down that corridor. And what their data shows is that it would be an impact of approximately 20 cars per hour. So that's fairly insignificant. I've asked the developer to, whatever information they have that's public on their traffic studies, to forward that. I also notified Senator Flanagan's office today that we've made that request so that we receive that. So we need to look at that first before we would need to decide whether or not we should do something in addition to that. Do you have?
Is this something that MRPC could assist us with in evaluating? Because I know that they've done some traffic work for us in the past, and obviously they're very familiar with traffic counts, et cetera. And I'm just wondering if that's expertise that we can tap into to take a look at whatever data the developer provides.
Yeah, they can, and they are ready, willing, and able. At this point, their review has been limited to identifying potential roadways and intersections that the applicant should be looking at. And they have identified Route 13 as something that should be looked at, but it is about at the bottom of their list. But I did speak with the executive director at MRPC, and they are willing and available to help, and I think that's our best bet. But I think the best thing is to get whatever traffic analysis the developer has and have them review that rather than try to do this ourselves. But obviously, we have a very tight timetable to look at that. But based on the information that's being provided, it seems that from a traffic perspective, the impact is not going to be significant on Lunenburg. The developer believes that most of the people coming to this facility will be coming from within 30 miles, so that they're going to be drawing locally to this facility. If the development is approved, once it's up and running, it will provide 600 full-time permanent jobs at all different levels, from working in the casino to security, to human resources, to IT. So from that perspective, that's very encouraging, because we, in this part of Massachusetts, our unemployment is higher than it is in other areas, so that is encouraging. There are also projected about 600 jobs through the construction process. If the project is approved, the timetable is, first, the application is due the beginning of October 2013. The Gaming Commission expects to make a decision on who they issue the license to by the end of this calendar year. The estimated permitting time is 6 to 7 months, and then the estimated construction is 12 months thereafter. So they would be looking at opening this facility in mid-2015. The company that is applying for this license is the Cordish Company. They are out of Maryland. They have a website up and running. You can either go to the City of Leominster website, and there are links to the Cordish Company. You can Google Leominster Casino, and it will come up. They have quite a bit of information. The company, they do operate a number of resort casinos in Florida, in Maryland. They have previously partnered with Hard Rock, and so they have quite a bit of experience. It is a family-owned company. In Maryland, where they are headquartered, they are a leader in philanthropic giving. They purchase 30% of their commodities from the county in which they are located. The developer noted to me that they would purchase more, but that's all that's available. There are certain things that they just have to go outside. He talked about their commitment to assist in local fundraising by providing a venue for fundraising. They do have an office locally that is open that people can go to if you're interested in meeting with them, in seeing the mock-ups that they have of this project. They are required by the state to invest a minimum of $125 million in this facility, and they're looking at investing $200 million. The facility will be built according to green standards. That's something that they are committed to doing and have done in the past. So it really is a very impressive project. And let me see, I think I had one more thing. No, I guess not. So the next step for them is Leominster will have their referendum, I believe, on the 24th, which is next week. They are looking for a strong turnout. Whether or not that will happen, I'm not sure. But the one thing I wanted to mention is the city of Fitchburg. You may have read an article in the newspaper that the city of Fitchburg has hired special counsel to negotiate an agreement with this developer for mitigation. I do have a call into the mayor. I was hoping to talk to her today. I wasn't able to get a hold of her. I did speak to her assistant, but they're looking at traffic. They're looking at social and economic issues. They're looking at potential impacts to the school system, maybe with people moving in for jobs, housing, that sort of thing. I do want to speak with her and find out whether or not, what prompted the hiring special counsel. I do believe that special counsel, I think it is paid for, or there certainly is a process for that to be paid out of the applicant's application fee. And I would imagine that is what Fitchburg is doing, but I have not spoken to them directly. I believe that they've taken this step because there's such a tight timetable. and not necessarily because they've identified impacts, but just they want to be able to address it on the timetable that the state is going to require. So that's something that we may want to consider, but again, based on what I'm seeing, I'm not sure that we would qualify for mitigation.
Mr. Chairman, I do think it's something we need to explore further personally, and I'm not a traffic analysis by any stretch of the imagination, but it does, 20 cars an hour seems low to me, given the traffic that is already on Route 13 and the type of establishment you're talking about. So I just think it's imperative that we do involve MRPC in looking at the data and ensuring that they concur with that data. And if they don't, then I think we absolutely need to look into the possibility of hiring special counsel, because I think there, we are within that 30-mile radius, and I think that there is a potential for significant traffic involvement. And as you know, the traffic on Route 13 is already extremely heavy, and I'm concerned about potential impacts. And as you said, the timeline is very short, so I think it's imperative that we contact MRPC as soon as possible for them to evaluate the existing data.
Mr. Chairman, the only concern I have with the concept of the Route 13 corridor is for anyone who travels to North Leominster at certain times of the day, you don't do it because you're backed up to Day Street, if not before that. And in fact, what people do is people find the path of least resistance, so they come off of Route 13, Highland Street, Main Street. We get the center of town that's going to be impacted. Lancaster Ave and Leominster Shirley Road, which just as a stop sign in the morning, there's at least 10 to 12 cars backed up there in the morning. People go on to Pioneer Drive because that's a good cut through, gets you to Route 190 fairly easily. But coming back, a lot of people will be coming back on Fort Pond Road, and that intersection with Leominster Shirley Road is going to be an issue. So I don't see it that Route 13 can't handle it, although Route 13 at Walmart, there's going to be issues there. Route 13 by CVS is going to have additional traffic there. So I think that regardless of the amount of traffic, I would echo Mrs. Bertram's concern about the number. We could be talking about enrollments again. But the fact is that it's an issue, and it will move from one road to another to find the path of least resistance.
Anybody else?
All set.
All set. Okay, end of the agenda before we leave. Next meeting, we do not have a meeting next Tuesday. It is the last Tuesday of the month. So our next meeting is Tuesday, October 1st, 2013. Any final public comment from the board?
Just wanted to note, I hope people notice that the Ritter building has been roofed. The library's in process of being painted. Again, tax dollars at work, voted at town meeting last year to maintain our buildings. I think it's incredibly important that people see that that's become more important to us, town leadership, because it's an investment in their town and their tax dollars. So maintenance is going on. Again, this building is a mess. We're all aware of that, and people may be wondering why we're not addressing that, and that's all part of the Building Reuse Committee ongoing, because again, we don't want to put money into a building we may not have, and we want to make sure we're spending properly and thoughtfully. So this building will get addressed in the not too distant future once we know what our future holds. So again, just wanted to thank the town manager and the facilities folks for getting those projects handled.
Okay, sorry. Any other public comment from the board? Public comment from the public? Mr. Rogers, welcome.
Chairman,
Really?
I am the sole member of the committee that's concerned about traffic on Highland Street. And I echo Mr. Ebersol's concern, and I would invite the entire board, the chief of police, and all the police officers to come and have coffee at 82 Highland Street early in the morning and late in the afternoon, so you can see what we're up against now. Obviously, that's a tongue-in-cheek comment, but your point is extremely well taken. I'm here to talk about 3 administrative things. The first of which, and I'm not expecting that you'll give me an answer tonight, but something to think about. The first is the concern I have about administratively, about the individuals that are appointed as, I'm not going to use the right term, sealers of weights and measures, or as it pertains to the P.J. Keating Company. And I want you to think about this for a minute. Here's the situation, and they're fine people. Don't get me wrong, they are fine people. But here is the situation. We have employees of P.J. Keating Company weighing the product that P.J. Keating Company is selling to an independent contractor that uses their scale so that they can be charged by P.J. Keating Company for the goods that they receive. That's tantamount to having the employees at the Gulf Station up in the center of town checking the gallonage to make sure that all the things are correct. I think there is a conflict there, and I just think it's worthy of something to look at. And I'm using the term P.J. Keating, but it's wrong, because I was sitting at home watching this, and I had occasion to listen to you talk about the licenses that were issued to the P.J. Keating Company, et cetera, et cetera, et cetera. Now, I don't know what the legal ramifications are or what is involved, but I'm not sure that the P.J. Keating Company really has those licenses. It's the Oldcastle Corporation that's running the P.J. Keating Company. And if you look back, as I have, because I was involved in a horrendous battle in this town years ago, some folks wanted to put the P.J. Keating Company out of business, and I didn't. You'll find that there is a trust that owns the land, and it's kind of convoluted. So we were here this evening talking about administrative details, okay? And I happen to think they're very important. So while it was fresh on my mind, I thought it was worthy of a discussion about this, and you can check into this later. Putting the P.J. Keating issue aside, Ray Powell has been dead for years. He was a dear friend of mine. We issued a license to Ray Powell. If it doesn't say successes or assigns as their interest may appear, or some other verbiage that's acceptable, administratively, I don't know how you can give a license to someone, God rest his soul, he was a great guy, that's deceased. So administratively, I think we have to look at those kinds of things. So once again, I'm sitting at home, enjoying myself, having a leisurely dinner, and I said, I got to get up there. So here I am. It's nice to see you all, and as I said, I wouldn't expect that you'd have the answers tonight, but those are the concerns that I have, and I'm sure that they'll probably be proven to be inconsequential and irrelevant, but I wanted to bring them to your attention anyway. Have a good evening, and thank you again for the opportunity.
Thank you.
Thanks, Dave.
The only one that I can answer is Powell Stone and Gravel, and I was reading from a spreadsheet that was prepared with the summary. The license itself, in both instances, is issued to Powell Stone and Gravel.
Okay.
And it's just listed as Ray Powell, and
Okay,
it should be changed.
and that's great, because when you read it, it was Ray Powell.
Right.
And then the next one was Powell, Stone,
Yeah,
and Gravel, and I said,
was.
I actually had a question in my mind, and then I assumed, well, and it said Raymond A. Powell Jr., and I didn't know his full name, and I thought, well, maybe Steve or Jeff is named
No.
Ray, and I just
Only
don't
one
know
named
that.
Powell Jr.
So I actually question that.
Thank you again.
Thank you.
Thank you.
Anyone else?
Just, I'm assuming that we do have a gentleman who checks weights and measures at the gas stations, et cetera. Does he inspect the scale as well? Or maybe we can find that out.
The sealer of weights and measures is independent. He's an employee of the town of Lunenburg. And he would check all of the equipment that Keating's uses on an annual or semi-annual basis, depending on what state law says. These public weighers is a step down from the sealer of weights and measures, who on a day-to-day basis, they are measuring quantities for accuracy using equipment that has already been certified by the sealer of weights and measures.
So it's like if you go to the gas station, you get a gallon of gas, he verifies the measures, same thing there, so maybe Dave will get it on the replay. It is verified, the equipment's verified. It's not like a conflict.
Mr. Chairman, just two quick things, reminding that when we set the agenda to make sure we get back to reviewing the policies. And now that we're at the end of September, which is 3 months into the fiscal year, it's a quarterly, and I think we're supposed to do a quarterly review of our goals. And that might be something to do sometime in October when we set the
We
agenda.
should also do a status of your goals. And entertain a motion.
A motion to adjourn?
Second.
Any further discussion? All those in favor, please say aye.
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 Opposed, none. Good night, everyone.
Good night.